Hey, 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 it's the bear. And here we are, Project 15 in estate planning Introduction to Planning for Marriage and Divorce. This is a rather short uh, CPA, both in terms of the reading and also this video. There are 5 questions to answer. You may need to do a little bit of online research to answer some of those questions, however. And all of the questions require narrative response. So we're going to cover prenuptial agreements, ERISA, and the rights that spouses get to qualified retirement plans. Divorce, how to split property. In a divorce, what is marital and non-marital property. Discuss alimony very briefly, and qualified domestic relations orders, which is something that financial advisors can sometimes see when you're required to split an IRA account, or not an IRA account, but rather a qualified retirement plan account like a 401k. And also a little discussion of dower, again, in the state of Kentucky, an elective share. All right. So let's talk about these things, including prenuptial agreements and all that. All right. Should you get a premarital agreement if you're going to get married? Well, who do you want your property to pass to if you subsequently get divorced, if you die and you're survived by a spouse? As a practical matter, very few young people, when they get married, get premarital agreements. In fact, I have never drawn a premarital agreement for anybody under the age of 30. Uh, I've been asked to, actually, by some parents, but I'll discuss that in a bit. So, if you do get married and then get divorced, how are things divided? Well, we have to figure out if the property is marital or non-marital property. Marital property was property acquired uh, anything during the marriage. The exception is for inherited property. Non-marital property is any property that was owned before the marriage, or and also inherited property if it can be traced. Now, in some states, you have to keep that separate, property separate. In others, you can go ahead and jointly title property. Uh, but typically, if you're trying to preserve your assets in the event of divorce, you really want to keep property in your own name. So here's an example. Mary owns a CPA firm which is worth $200,000 at the time she gets married. She weds Joe. Joe's a high school teacher. They don't have any children. They accumulate the following assets after the marriage. So other than that CPA firm worth $200,000, no other assets that they had. Mary then accumulates in her 401k $140,000. Joe has a 403b, which is like a 401k, but it's for government employees, like Western Kentucky University. That's 80,000. They jointly own a home. It's worth 250,000. They still have a balance of the mortgage of 160. Joint checking account of 10,000. And Mary's CPA firm has increased in value to 400,000. What is marital property? Again, that's property that was acquired by inheritance during the marriage. There's no facts that indicate that, or that was owned prior to the marriage. And in this case, the CPA firm is non is rather non-marital property. That's the property that is not marital property. Everything else is marital property. So basically, how should the property be split? Mary CPA's firm, the entire value of that firm goes to Mary, and everything else is split basically equally. Now, in a divorce case like this, often one spouse will buy the other spouse out of the home, even if they have to get more mortgage on it to do that, or pay them out over time. That's quite common. There's usually an agreement worked out to that effect. If not, the judge could order that the home be sold. For the 401k and 403b accounts, that might be taken into account depending on who gets the value of the home, the equity in the home. That might be used to help offset that, or there might be a transfer from one of those qualified retirement plan accounts to the other's qualified retirement plan accounts, or more typically a rollover IRA account. All right, so again, the non-marital property in this case is only the CPA firm, even though it has increased in value. Now, in some divorces, for example, Joe might say, well, you know what? I I actually helped out in that CPA firm. I came in and I restructured the office in some way. I restructured the computer software. I helped manage the business, and therefore, some of the growth of that value is, in fact, due to my efforts. And in that case, uh, the judge will likely take that into account when dividing up the property. Uh, may not consider it fully marital property, but it might consider a good part of it non-marital, 200,000, and maybe the rest marital or something like that. Judges try to do what is fair given the unique circumstances of each case. Right? Most of the time in divorce proceedings, judges aren't the ones who divide up the assets. It's usually an agreement worked out, often through mediation between the attorneys and the parties. The attorneys are giving advice, but sometimes, yeah, you gotta go to the judge. Yeah, and just let the parties they can't decide, and just let the judge do that. I remember one case I handled as an attorney. I was representing this elderly woman. She must have been 80 years old. There's a elderly man represented by on the other side. The only assets they had was a house, very modest house. It was worth like $50,000, $60,000. Uh, Hardly any savings between them. Uh, just a little bit of savings. They both had Social Security. They didn't have anything else, and yet they were fighting over everything. They were fighting like who got the couch and things like that. Yeah, and we could not get them to agree on even selling the house or anything of that nature. And basically, the other attorney and myself went into the judge before the parties came in, before the clients came in, and the judge said, "What is this case about?" And I looked at the other attorney. The attorney looked at me and said, "Judge, this case is about hardly anything at all. These people have been married for 60 years. They are going to get divorced. Uh, there were some reasons for that, and uh, and they really don't have a lot to argue about." You said, "Well, bring them in. Let's have them have their say." And the judge just did what he thought was fair. There's really not a lot of astute uh, litigator type things that anybody can do in that case to help anybody along. Splitting qualified retirement plans and IRAs in a divorce. If it's an IRA, all you require is the divorce order, usually called a dissolution of marriage order, that directs how the IRA should be split. It might say this dollar amount is to be transferred or this percentage of the account is to be transferred. It's usually just a line in the court order. But for 401k and 403b plans that are governed by ERISA, and not all 403b plans are governed by ERISA, but there's also some other types of account like uh, that are covered, like certain 457 plans might be covered by ERISA. Uh, Also, ESOPs are governed by ERISA. So there are certain types of retirement plans done by businesses. You have to have something called a qualified domestic relations order. It's a separate court order. It's usually prepared by a tax attorney who does this as kind of a specialty. It's usually 5 to 7 pages long, somewhere in that range, double spaced. All right. It has some very technical language that has to be followed in it. And actually, as a tax attorney, I used to do this a lot. I didn't do divorce work after a while. I only did that for a couple years early in my legal practice. But later in my legal practice, as an estate planning and tax attorney, I would often draft this for the divorce attorneys in my county. So uh, here's a situation. Uh, Actually, this situation is a situation that confronted me. Norm and Betty own a car dealership company. I was actually a general counsel for the car dealership, and also on the member of the board of directors. They were my clients. They're car dealerships. They actually own 5 different car dealerships in the area, uh, and in the land underneath it. It was all worth about $10 million. And their sole child, Sean, was to inherit somebody. Now, Sean was at the time age 25, and he was beginning to manage the car dealership, which was the plan all along. Sole child, right? Interestingly enough, I had the opportunity to move across the street from Norman and Betty in a nice neighborhood overlooking the water, and down in Florida. And Sean at the time was about 15 years old, and he was into drugs and things like that. And I had a 14-year-old daughter at the time, so I did not move, even though I really liked the house, really liked the neighborhood, really wouldn't mind being across the street from Norman and Betty. I did not move and become their neighbor simply to save my 14-year-old daughter from having to deal with or potentially getting involved with Sean. It took Sean several years to get through college. But now he's 25. He's beginning to manage a car dealership. He's getting married to Bimbo, a 23-year-old gold digger. At least Norman and Betty think she is. Sean has little assets now, but Norman and Betty want to recapitalize the company and shift common stock ownership and control of the company over to Sean. Norman and Betty want to retire within the next 5 years. And there's different ways of doing that. There's some estate tax planning at the time where the recapitalization of the company had some estate planning benefits beyond what we'll even discuss later in the course. So, should Norman and Betty insist that Sean get a prenuptial agreement? Now, Norman and Betty actually came to me. That's not their real names, but they actually came to me and said, "We want you to represent our son Sean and get a prenuptial agreement." And I said, "No, you don't. What you want instead is to put everything into a trust for Sean that is protected in the event of divorce." So that would clearly be a lot better from the standpoint of protecting Sean. Uh, and as we'll explore this, and there's reasons why even with the prenuptial agreements, they often uh, go by the wayside over time, or there's problems enforcing them. Right? So what's required to get a prenuptial agreement? Uh, Often, if you're in a second marriage situation, you have children from a prior marriage, you've accumulated assets, you're likely to get a prenuptial agreement. Or if you're older, a lot of people down in Florida that I used to represent were in their 60s, 70s, they were getting married, some for the second, third time. Um, it must be in writing. You have to fully disclose in advance all of your assets and your debts and your income. And the agreement must be fair and equitable to both parties. You just can't take like one rich person and one poor person and say, the rich person says, "You're not going to get anything if we get divorced." You have to be fair about it. And fairness is often dictated by how long you've been married. And there has to be no undue influence or coercion. Strongly, strongly encourage that each party get their own independent legal counsel. And in fact, I had a client one time who was getting married to a gentleman. He came to me and said, "We just want you to draft the agreement." I said, "No, I can't do that. I can only represent her. You have to get your own legal counsel." He said, "I don't want to do that." And I said, "I will tell my client not to get married unless you get independent legal counsel." And I was that stern. I'll go into that a little bit. It's also advisable to do it months before a wedding, not the day before. If you do it the day before, that's indication of undue influence or coercion. So even just a week or two before can be that. So if you're going to get married and you got to get a prenuptial agreement, you want to get that done well in advance of the marriage. Now, prenuptial agreements are not fun to do. They're not fun to actually negotiate. All right, it's kind of like getting divorced in advance. In many respects, it covers what happens if we get divorced. It also covers what happens if one of us dies. So, pretty hard to negotiate. In fact, I did a lot of prenuptial agreements as part of my estate planning practice, and I would say of all the ones I did, at least a fourth of the people who were going to get married did not get married because of the negotiations around the prenuptial agreements and the like. So, let's go back now to our situation before Mary owned the CPA firm. There's 401k accounts, the joint home, all that. But now, what if they have a child, Bobby Sue, age 8? Well, forget the name Bobby Sue, for example. That's kind of a bad name, I guess. But what happens at that point? What is marital property? Or it's non-marital property? The same thing. But how should the property be split? Completely different. Now we kind of look at the primary goal of the divorce proceeding is to ensure that the child's standard of living is maintained. that the child is provided basically financial security at that level at the time of divorce. All right, and in fact, not only would it affect who gets the home, for example. For example, some divorces say the custodial parent will get the home until such time as the child goes off to college or is 18, whichever is later or earlier, something like that, and then the house will be sold or something like that, or it might be awarded to one of the parties, especially when you have a really young child. You can also have to determine child support. So here we go to the Kentucky Child Support Interactive Estimator. This one child. There's no current child support obligation for like another child. So we'll continue this. How much does one child make? We'll say that the custodial parent, we'll say this is Mary, is going to be the custodial parent, and she makes $100,000 a year. Okay? And she doesn't have any other child support or maintenance. If she has child care costs, we'll say that she has, we'll say $5,000 of child care cost for after school. All right. Now, we'll go to the non-custodial parent. And we'll say, okay, he was a teacher. We'll say he makes $55,000. All right. And has no other child support obligations. Doesn't have any child support. He's the non-custodial parent, which means the child does not live with him during school time. And that was $55,000 per year. Then we continue this, and then we say, wow, this is the amount that's due from the non-custodial parent to the custodial parent, $2,177 a month. That is incredibly high, given that he only makes $55,000. That's his gross pay. His net pay is probably, because of income taxes, down around $44,000, and he's paying more than half of that in terms of child support. So, wow, I'm not sure this makes a lot of sense, but it's an interesting site here from the state of Kentucky that basically allows you to estimate child support. All right, let's discuss getting married. All right, can you get an annulment if either party is already married before they get married? Yeah, that's obviously because the contract for marriage is basically unenforceable at that time. If you've already been married and you haven't gotten divorced. If the spouses are closely related, cousins or closer. I guess the exception there is for West Virginia, where cousins marry each other all the time. I'm just kidding. Just kidding if you're from West Virginia. All right. If you're under the age of consent, the age of consent in most jurisdictions is 18 or 16 with parental consent. So if your parent agrees you're 16, you can get married. In the state of South Carolina, if your parent agrees, it's 14 years old. And a judge can approve you getting married at the age of 12 or older, which is incredible. Again, that's South Carolina. And if there's want of understanding, if you're incapable of agreeing to the marriage at the time you said I do, or if there's fraud undertaken. So we got all these different ways of getting marriages annulled, okay? Let's say Bama, we'll say Bama is his name. He met Sue in Las Vegas. They agreed to get married. They partied hard. And then they both went to the wedding chapel and got married, both under severe intoxication at the time. Yes, they were married by Elvis as well, the chaplain. Right after they got married, en route back to the hotel, Bama stopped off at the liquor store. He purchased several bottles of booze and a lottery ticket. The next morning, Bama awoke. After a couple of hours, his friends told him he was married. He didn't remember. Sue didn't remember either, but she didn't mind. All right. And late that afternoon, Bama checks his pocket, finds the lottery tickets, checks the numbers, and discovers that he won $25 million in this lottery after taxes. Bama rushes out of the room without telling Sue. Can Bama file for an annulment? And if it's granted, who gets the lottery winnings? Well, this actually was a legal case involving a very similar fact situation to this one in the state of Nevada. And yes, Mama can get an annulment. Why? Well, we go back. There's a want of understanding. They were incapable of agreeing to the marriage at that time, basically intoxicated. Yeah, a lot of marriages in Las Vegas actually get annulled. No surprise there. All right. And who gets the lottery winnings? Well, they weren't married. All right. He gets the lottery winnings. Mama does. She doesn't get anything. And that case was actually decided again in the state of Nevada. So, again, prenuptial agreements are hard. I represented a doctor. He was about 50, 55 years old. He had some children from a prior marriage. He kept on dating these fairly younger women, like 25 and 30. And he came to me three separate times, to get prenuptial agreements. Now he had been taken over the coals in a divorce, and basically he wanted to try to protect as much as he could. So the prenuptial agreement was worth a couple of $1 million. Of course, the people he was dating weren't worth hardly anything at the time. And I remember she said, we were laying down on our bed and doing pillow talk, and she said she would sign anything I put in front of her. Well, guess what? I did a prenuptial agreement and tried to make it fair, so that it would pass judicial scrutiny later. That basically provided, if they got divorced after 1 year, after 5 years, after 10 years, and so forth, how much she would get. And in prenuptial agreements, you really can't address what happens if there's a child, by the way. You can't agree in advance on that. That's all determined by judges. Judges have to approve anything relating to children. And they don't do that in the context of if you have children. It's only when you get divorced. But anyway, so I handed the agreement to the other attorney representing her. It happened to be her sister was the attorney. And they got very upset with me for basically ruining the marriage. And in fact, 3 different prenuptial agreements I did for him, not one of them led to getting married. And I said, "Gosh, I told him I'm so sorry about this. I don't I just I'm sorry that these prenuptial agreements that I've been doing for you are preventing you from you know getting married and being happy." And he said, "Don't worry, I am happy. I mean, how many 55-year-old guys have to have sex with a lot of 30-year-olds?" Yeah, so just interesting. Did another prenuptial agreement for a lady. She was about 80, 85 at the time. She went on an Alaska cruise. She had survived 6 husbands. All right? Some of them were very wealthy. In fact, she was very wealthy as a result of surviving 6 husbands. All right. She went on a cruise. She met one of these gentlemen on cruises. There's a lot of men who basically get free cruises in order to basically spend their evenings dancing and wining and dining and doing other things with the women on cruises. They actually, some cruise lines foster that. And so she met him. He came back all the way to Florida to marry her. He walked in my office and said, and they both said they're going to get married. I insisted that he get another attorney. And I actually wrote in the agreement that, which is not common in Florida, that if anything was put into joint names, ever, that it remained her property. And in fact, she passed away. He had taken a power of attorney, which I told my client not to give him, had transferred while she was incapacitated some property from his name into joint names. And in fact, through negotiation, we were able to get most of that property back. All right. Okay, a little technical issue. If you get married, right, only a spouse can waive spousal rights to employee plan benefits. So, a fiance is not a spouse. So, for example, if you have a prenuptial agreement, you say, "Hey, if we get divorced later, you're not going to get anything out of this 401k plan." All right. Then what you have to do is basically agree to waive in advance, and essentially you have to have the prenuptial agreement, and then you have to have a waiver form that's signed after the parties get married. Once had a gentleman who was fairly old, about 66, 65 or so. He had a heart condition. And he said, if I get married and I don't secure this waiver, I mean, I could have a heart attack during our honeymoon. I won't get into why, but, like, so what happened is he invited me to the marriage, paid me to come to the marriage ceremony, and we had the prenuptial agreement done a couple of months in advance. But after the marriage, before they went on their honeymoon, she signed the waiver to the 401k plan. Um, that's interesting. Unfortunately, it's a federal law, and there's no way around it in terms of waiving rights to 401k plans. Can only be done after you're married. All right. What's required to get divorced? It varies from state to state. All right. If you get divorced in Las Vegas, it's actually you can do that pretty quickly. You don't even have to be a resident of Las Vegas, of Nevada, to do that. But in most states, it's 6 months. Some states, 12 months. You have to be a resident of that state. You have to have irreconcilable differences, which is you don't really have to prove it. You don't have to prove that you have any cause like, oh, this person did some wrong to me, or there was some fault in the marriage. You don't have to do that. It's just irreconcilable differences is all you have to allege. You don't even have to prove it. And then states require marriage counseling often, especially if there are children born at the marriage. So here's some takeaways, just some practical things. Uh, Younger persons rarely ever get prenuptial agreements upon marriage. If you have parents who are going to leave substantial property, leave it into a trust, an irrevocable trust with a spendthrift clause. Basically prevents that from being taken in the event of divorce because it does not become that person's property. They are only the beneficiary of a trust. When older persons get married and they have property from other marriages, they usually obtain prenuptial agreements. They need to have separate legal counsel, always, strongly advised. And that agreement is going to address what happens if they get divorced or die. It cannot address child support, so if they're going to have children, it won't address that. But it can address these other things. All right. I would say also this: when I draft a prenuptial agreement, often what happens is after somebody's been married for about 10 years, a lot of times the person will come back to me and say, "We want to rip this up." You can actually modify prenuptial agreements with something called postnuptial agreements and modify what was done before. You can do a postnuptial agreement. So even if they didn't get one before they were married, they could get one afterwards. Of course, it's usually harder to negotiate at that point. But you can also rip them up. You can basically say, oh, we're just going to treat it as all this is marital property, and they'll name each other as beneficiaries at that time and stuff like that. So prenuptial agreements often don't last very long, as a matter of fact. All right. Upon divorce, marital property is split equally, including the appreciation and value of separate property, but not always. It depends upon the state. As shown in the prior example, appreciation and value that was solely the result of her efforts may not be considered uh, uh, marital property, especially if the appreciation and value is just something that happened as a result of inflation, for example. If children exist, the courts will divide property unequally to ensure the property proper support and award child support. Alimony, by the way, also gets awarded, especially if you've been married a long time, and especially if there's disparity in income. So, for example, my wife and I have been married for 38 years. All right? My wife worked to put me through law school. So, and we were married during that time. And since that time, she has basically managed our home. She's also helped me out in my various businesses in some ways, office manager and the like, on a part-time basis. She's been very instrumental in all of that. But I would like to say that if I ever wanted to get divorced, I'm messed up. I'm basically half and half, and she would take not only half of all the property, which is all marital property, but she would also take a fairly good amount of alimony, probably equal to half of my earnings at that point. So I'm stuck. Yeah, I'm stuck. All right. Fortunately, the average couple getting married today has a more than 75% chance of staying married I would say the average young couple is getting divorced. That means only 1 in 4 recent marriages are likely to end in divorce. Some new statistics out there. I've heard 40% in terms of the percentage of getting divorced, but I think in terms of new people getting married today, it's even lower than that. Surprisingly, a lot of what's interesting is a lot of older people um, are getting married, are getting divorced, even if they've been married for a long time, usually around the time of retirement. In fact, this whole coronavirus thing, and I'm working at home, it's kind of like been a test, you know, which is like, hey, if I retire and I come home and I'm at home all day, and my wife and I are going to get along. I guess that's the reason she moved my office from the alcove off of our bedroom to our guest bedroom, which is on the other side of the house, and basically confined me there. Um, so it was it's an interesting experiment. We'll put it that way. All right. Marriage is a partnership. You proceed through life together, and it's not just a financial partnership. It's also a partnership in terms of intimacy and also in raising children for many marriages. So, some advice: marry only a person who is also your closest of friends. Why? Because the passion at some point is likely to disappear or at least diminish substantially. You need to be able to talk to that person honestly and openly, and that person really needs to be a close friend. You need to have that close connection with them. Really get to know people before getting engaged. Have a long engagement, a year or two. All right, and ensure that you agree on what basically. When I got married, the minister sat down with my wife and I and said, "Here are the things that could really wreck your marriage." All right, disagreements about sex, disagreements about religion, disagreements about or tensions relating to money, and disagreements about how raising your children. And I can tell you that in divorce proceedings, these are the sources of tension in marriage. You got to have these things sorted out in some way. So that's all for this video. And tackle the readings. Not a lot of readings, some interesting questions that will take you time to answer, however. So